Good afternoon and welcome to the latest in our series of residential property forums. I'm Robert Kelly from Stewart Title, and we are as always joined by Ian Quayle of IQ Legal Training, who will be leading this session, talking about some topics which you have raised since the last session and some other things which have happened of note, but then really, as always, importantly, throwing the floor open to you to share your knowledge, to discuss problems you're facing in what is, of course, as we know, a particularly busy time of year. We're now looking down the barrel of the increase in stamp duty and looking at some of the ones, particularly for first-time buyers, Ian. It's quite a burden, isn't it? If you miss the end of March, it can really make a difference to people.
Absolutely. Yeah. I think it's the cliff edge that's being described looms, and I think as you get closer and closer, there's panic. To be fair, Robert, I thought at the beginning of January it was sort of moderately sensible in that people were working towards getting matters completed, but there didn't seem to be the sort of normal sort of panic. So I thought, things are sort of fairly steady away. But as we get nearer to the dreaded date, I think the panic is setting in. And you're right, first-time buyers, there's potentially a significant saving, isn't there?
Yeah, there is. I mean, we're already getting lots of inquiries about title insurance to help speed up the due diligence process and protect clients, particularly no search policies, which obviously we offer. And really, when we look at some of the delays, we're already too late to get a local authority search back. The issue started before Christmas in a number of local authorities. So if anyone is interested, we do have those policies available online. We also have our normal range of policies, details of which are on the screen at the moment. Bear in mind that where you discover a problem during the due diligence process, title insurance can give you a weapon for the future. As we all know, it doesn't get rid of the problem, and you need to explain to your client what it does and doesn't do. But it is a way of getting the transaction over. And as we're looking at considerable savings in thousands of pounds for first-time buyers and people at the lower end of the market, we're certainly very willing to talk to you about ways we can help with that. As always, any more complicated issues, go to our bespoke team who can deal with you there. And we continue to run these sessions and some webinars on legal topics. We are going to be joined in March at the next residential property forum by Nationwide. I don't know if there's it's just the chat room allow pantomime booing.
I think Ian, so. I think, well, especially for that one. I think we should. I think we should. Yes.
So they are very bravely coming along to talk to us about their views on transactions, on lawyers, and indeed on title insurance. So we will be sending details about this week. It's on the 10th of March at the normal time of 12:30, but it will be a chance for you to talk to them even before their latest ideas. They are the major lender in the country, so it's very useful to speak to them and very good of them to come along, spend time coming to talk to us. So we hope you will enjoy that as a bit of light relief in the middle of March. So we will send you details there. In the meantime, Ian, we are ready to speak to people and to, if anyone has any issues, our contact details are in the slides. So please get in touch. But lots to talk about, lots to do, Ian. So please get started.
Robert, just before I do that, Robert, one or two things. First of all, Sue Brooks says, looking forward to the Nationwide attending. So I think a lot of people are. Robert, the other thing I wanted to mention is you've got a number of new recruits, haven't you? A number of new underwriters. So that's good to hear on the basis that, A, obviously business is good, and B, particularly things like bespoke policies, the more the merrier with regard to underwriters, on the basis that you've got people within the office that can offer assistance and guidance with regard to bespoke policies. That
is right. We've had 5 new recruits since the start of the year.
Fantastic.
4 of them on the underwriting side, one equally as important on the admin side, because processing online orders and invoicing and so on is an important part of it. That's been dealt with. And also, yes, new underwriters, which is great for us. They obviously bring more resource, bring some new ideas, some new ways of dealing with problems. So they're all available, and working closely with our existing team with the aim, obviously, that provide you a safe service, but speedy as well. So we want to be able to put the resources in so we don't compromise the quality of the product, but do increase the speed.
Fantastic. And the last thing to mention before we sort of dive into topics, etc., we've got a series of conferences sponsored by Stewart Title. There are still places available. We've got one in Chelmsford, one in Northampton, one near Ripon in North Yorkshire. Do come along if you can. Lots of interesting speakers, lots of sponsors, and Stewart Title, Robert and the team will be in attendance, so you can talk to Robert and his colleagues about issues or problems, compliance training, you name it. Stewart Title is able to provide you with it. So again, Robert's colleague Freddie there has his contact details on slide, my details on that slide. Let's dive into the topics. So the first thing I wanted to talk about was advising on searches, client inspection and survey. And just to talk about a number of things. Firstly, with regard to searches, we're still waiting for the Law Society guidance note relating to climate change. And on speaking to 2 or 3 people in the last 2 weeks, it seems that the smart money seems to be that guidance will be available in June, July. The smart money also seems to be that there isn't any sort of anything really earth-shattering in the guidance, which will be aimed specifically for residential conveyancers. But some of the risks associated with climate change have been expanded to include things like wildfire and drought. But so again, the guidance is important. It's awaited. It is Law Society guidance, so it will be something that conveyancers have to consider. Put simply, I'm saying to practitioners, just do as you're currently doing and advise resi clients that it is possible for you to obtain on their behalf a climate change report that will look at risk associated with climate change. And again, when the guidance comes out, have a look at it, modify retainer and report on title to ensure that your wording is compliant with the guidance. Remember, the old guidance back in 2023 was more generic in nature and aimed at all practitioners, not just conveyancers. The new guidance will be aimed specifically at residential conveyancers, from what I can gather. So searches, again, important. Robert just mentioned problems with delays with local land charges searches, and the fact that Stewart Title has a delayed search product and a no search product, depending on lender and client requirement. There is assistance there for you. As far as other searches are concerned, again, I was just talking to someone this morning about this, looking at their retainer and saying, I don't think it's sensible to talk about usual searches in the context of residential conveyancing or indeed commercial transactions. I think it's better to talk about essential searches and then to talk about necessary searches dependent on location, client objective, etc. To talk about usual searches, I think, can be a bit confusing from a client's perspective. I think they're not usual. I think they are essential. And again, I've bleated on this point to you on a number of occasions in the past. Do think about additional inquiries of local authority as well as inquiries of local authority. And do make sure that in a specific context where there's a risk of development in the area where the property is situated, although not necessarily adjoining or adjacent to the property, additional inquiries of local authority will provide additional information about activity in the vicinity that could be of interest to the client. Next thing I want to talk about is client inspection. And as Robert said, remember, you can type in the chat box any topic that you like to explore, including our friends at the Nationwide Building Society, and we're happy to go off at a tangent or talk about whatever you wish to talk about. But client inspection. Last week, I was looking at a firm's report on title, and I was concerned about how they dealt with client inspection, in that they told the client in the retainer and in the report on title about the importance of client inspection. But in looking at a report on title, I'm thinking, well, all right, all you've done is reminded the client what you said in the retainer. In the report, I think you should be specifying, Mr. Client, we asked you to inspect. You've told us that you have inspected, and you advised us that when you inspected, there was nothing of concern. Or we told you to inspect, you have inspected, and you have identified some issues that we've investigated, and this is the result of that investigation. Or we told you to inspect, and you haven't inspected, and therefore you need to be appreciative of the fact that there could be risks associated with the property that you will not be aware of as a consequence of your buying blind. And the other point with regard to client inspection is something that I'm going to touch on a little more with regard to the famous moth case. And in the famous moth case, there is an argument, of course, that caveat emptor has to an extent been eroded. And therefore, you know, because caveat emptor perhaps no longer applies, and perhaps clients can place more reliance on the information the TA forms, does the need to inspect sort of reduce or limit? And I don't think it does. But I think with client inspection, you've got to say to your client, one, it's important that you check what the seller is saying against what you see when you inspect. And it's important to bear in mind that the questions in the TA forms could be used as a checklist by you to ensure that when you do inspect, you're looking for the right things or right issues. And then the last point I make is survey and valuation, and the need to ensure that clients are told about survey and that you read the survey report. Again, in the report on title I was looking at, the firm had said, we've annexed the survey or valuation that's been produced to us at the end of the report on title, but we are not commenting or advising on content. And I'm thinking, well, you can't really do that. You either draw to the client's attention what the surveyor has said that you need to consider as a solicitor or conveyancer, or you say to the client, the survey or valuation doesn't reveal anything that would warrant any comment, explanation, or advice from us. Hi, Zara. Zara's got a point. I've got one where the garage is missing from a transfer, and the previous lister saying it's the client's fault, as they signed the plan and said it was all okay. Yeah. Again, it's a good idea to send plans to the client. It's also a good idea, I think, to make sure that the client is aware of how the property is described. And missing garages and missing gardens are a sort of a staple, aren't they, of problems that can arise, Zara. And Sarah didn't remember they own two titles. Well, yeah, there's a surprise. Again, it's amazing, isn't it, how solicitors and conveyancers get flack about the conveyancing process, but how often are there issues that could be addressed early and resolved early on if clients help you and provide you with assistance and guidance. So yeah, Zara, that I must see probably one a month where a garage or a garden is included within a property but excluded from the transaction. I had one last year where the company that was a landlord with regard to a leasehold garage had been dissolved, and therefore there was an issue about how on earth the position could be tidied up, which was a bit of a disaster, really. Okay, so on from that then, and let's talk about moths for a moment or two. The Partak Karichavili case and Woodward Fisher, really interesting case. You'll have all heard of this, I'm fairly sure. Yeah, anyone not? Very expensive property in central London. Mr. Woodward Fisher seems to have been very sort of conscious of ensuring that during the renovation of the property, his contractors used materials that were environmentally friendly, which meant that lamb and sheep's wool was used for insulation. Unfortunately for Mr. Woodward Fisher, and indeed everybody else, the wool had been exposed to clothes moths, and they had infested the fleeces that had then been put into the walls as insulation. It would seem that Mr. Woodward Fisher knew about the problem, because it transpires that he'd had pest control companies out trying to attend to the moth problem, which was a significant problem. And when the claimants purchased the property, Mr. Woodward Fisher completed the TA forms, one of which asked about the existence of vermin, and one of which asked about awareness of infestation. Now, it appears that Mr. Woodward Fisher contends that he asked his solicitors for guidance with regard to those two questions and was informed that you couldn't have an infestation of moths and that moths weren't vermin. So it appears that on guidance from his lawyers, Mr. Woodward Fisher advises that he's not aware of vermin and not aware of any form of infestation. Now, if that's right, I think Mr. Woodward Fisher, given what happened to him in this claim, is going to pursue a claim against his solicitors. The issue is, assuming, of course, that he's telling the truth. Anyway, property purchased, the claimants move into the property and immediately encounter a sort of biblical problem, with moths appearing left, right and centre on a regular basis, thriving in the wool within the walls due to the heat and damp that the wool generated. They instruct a number of pest control companies to come out and have a look to see if they can address the problem. Two of those companies were aware of the property and had been asked by Mr. Woodward Fisher to deal with the problem before he sold. So that blew Mr. Woodward Fisher's argument about lack of awareness, if he was going to raise that in his defence, out of the water. So, two things. One, the moths start obviously creating a sort of a nuisance, flying around, fluttering around the building. You can imagine that. But in addition to that, they seem to have a very healthy appetite for very expensive clothing, carpets, curtains, etc. So the claimants then bring proceedings for misrepresentation. As far as those proceedings are concerned, the unusual feature of the case is that the claimants seek rescission of the contract and allege fraudulent misrepresentation, entitling them to get their money back. So the matter goes before the court, and the court finds in favour of the claimants and does indeed order rescission and does indeed order Mr. Woodward Fisher to return the money and resume his title. They also are successful in claiming damages from him for damage to the clothing, the carpets and floor coverings, etc. The only thing the judge does say is, well, you did live in the property for a period of time, albeit you didn't enjoy it as much as you ought, but that we are going to take into account some form of notional occupational rent. Now, the interesting thing about this is claim of fraudulent misrepresentation. Mr. Woodward Fisher knew and deliberately concealed the problem, or he was reckless in that regard. Liability established, claim successful. The takeaway points from this case are as follows, in my view. One, if ever there was a case that highlights when you're acting for a seller, the importance of warning the seller to take the questions that are raised in the TA forms seriously, and an obligation on the seller to answer the questions honestly. Now, you can imagine Mr. Woodward Fisher, when he's faced with these forms and he's taken them home or downloaded them from his computer and he's sitting at the kitchen table contemplating, how do I answer these questions? And his thought process must be, well, if I'm brutally honest about the problem, my claimant buyers are going to disappear off into the sunset. I nearly said they would disappear off into the moonlight, which would be more appropriate for moths, perhaps. But anyway, you get the point. Or do I just simply not answer the question, or do I answer the question through rose-coloured spectacles, or do I just blatantly lie? What was in Mr. Woodward Fisher's mind, who knows? Let's give him the benefit of the doubt and say, well, he asked his solicitors how to answer the questions. I think the takeaway point from this is the idea of some form of legalistic response or legal gymnastics to determine what is vermin and what's an infestation goes out of the window. If you're aware the property is suffering from anything that could be remotely connected to vermin or an infestation, you disclose it. And, you take the consequences of the buyer saying, thanks very much, but I don't want your property anymore. The other thing is this idea about fraudulent misrepresentation, allowing rescission of the contract and allowing the parties to resume their original positions, is an interesting one. Zara says, a lot of hype about the moth case and how it would have been prevented by material or upfront information. Well, I agree with you, Zara. I think if we assume take Mr. Woodward Fisher at his worst, the fact that there's upfront information wouldn't have made the slightest difference. Okay, if you assume that the infestation was horrendous, the disclosure of its existence would scare a buyer off, and depending on what Mr. Woodward Fisher's circumstances are, depending on how difficult it would be to eradicate the moths, you can see how drastic a situation that would be, and why Mr. Woodward Fisher took the approach that he did. But what I'm worried about here is liability for the seller's solicitors or conveyancer. I think you've got to drum home the point that, look, you need to answer these questions very carefully. The other thing that I think is interesting from this case, and it's also an interesting point on another case that we looked at in the past. Remember a case called Rosser against Pacifico? If the replies to TA forms are given additional credibility, are given additional legal value, in that misrepresentation isn't sort of a potential claim, but actually is a claim that aggrieved buyers can utilize to seek redress, to what extent does that remove or reduce sort of caveat emptor? Because if we're going to look at caveat emptor, we would say to the claimants, well, you should have had the property surveyed or valued, and the surveyor or valuer should have spotted the problem. Or you should have inspected the property, and had you inspected the property, a reasonable inspection would have revealed this issue. So, to an extent, is caveat emptor sort of reduced? It's certainly not eliminated. But if you look at Rosser against Pacifico in particular, the judge there was saying the seller is in an ideal position to furnish the buyer with as much information as is possible about the property. And therefore, answers to the TA forms should be answered in that light. Okay? And yes, Zara, you're right. TA forms are being answered incorrectly. From a buyer's perspective, though, what can you do? Do you raise additional inquiries? Are you really sure that there's no vermin? Are you really sure that there hasn't been an infestation? Can you now say that the position is now clear as a consequence of this decision? Again, to what extent is, a dictionary definition or terminology interpreted by a judge in this case precedent for future cases? It's an interesting one. There was a case in Scotland, wasn't there, about what constitutes vermin? And again, I think it was insect infestation, which the court held was vermin. Could have been, Zara. I don't know. But it's a really interesting case, and it just means we've got to really tighten up when we're acting for a seller about what we say to the seller in answering the questions. It really got to tighten up to make sure the seller is aware of the warnings on the front of these forms. Really warn the seller about the fact that we're simply checking what they're selling against any information that we're holding on our file, and doing nothing more than that. I'm sure with regard to a lot of potential claims, Zara, you're right. There is a sort of automatic bar to litigation on the basis of exposure as to costs. I think that's a good point, Zara. But just going back to this case then, when you're acting for a buyer, I think it's important to advise still about survey, still about client inspection. And again, with regard to the TA forms, saying to the buyer client, look, exploring Zara's point a little further, you could potentially sue the seller for misrepresentation, but you're unlikely to have an appetite or indeed the resources to do so. The other last point I'd make with regard to this is that Mr. Woodward Fisher was sued for fraudulent misrepresentation. And the thing that baffles me about this is that if the claimants are right, and Mr. Woodward Fisher was well aware of this infestation and well aware of the problem, and failed to disclose it, and it is fraudulent misrepresentation, which what was Mr. Justice Fancourt determined in the trial, then surely he's committed a criminal offence under Section 2 of the Fraud Act. So, why didn't the claimant notify the police, or why haven't they notified the police? Now, my guess is all they wanted was their money back, or to forget about this terrible property and go and buy something else. So the fact that Mr. Woodward Fisher would be subject to criminal sanction isn't really going to be of direct financial benefit to them, and perhaps that's why the matter wasn't reported. But it seems to me at the claimant's best case, this was clearly an example of a criminal offence being committed under Section 2 of the Fraud Act. I suppose if we're looking at Mr. Woodward Fisher and giving him the credit of the benefit of the doubt, he might say, well, he answered the questions on the basis of legal advice, and therefore, the responses weren't fraudulent in those circumstances. Interesting one. Okay, next thing I want to talk about, and again, has anyone got any other topics to put in the chat? You remember, it's not my day-to-day, it's your day-to-day. Please put in any questions that you've got about anything or topics for future presentations. Fire away in the chat. But the next thing I want to talk about is online auctions. For the last 3 weeks, I've been doing some training for a company that is sort of amassing clients who are buying residential and commercial property at online auctions. And the idea is that, what do buyers buying blind expose themselves to with regard to online auctions? So it's really quite an interesting exercise. And a number of things become glaringly obvious. Some fairly sophisticated buy-to-let investment buyers who you'd think would know the conveyancing process and who you'd think would know the online buying process in connection with online auctions don't understand the process, don't understand the significance of client inspection, don't appreciate the potential problems that an online auction generates. The second thing that was really interesting is that there's a number of online auction houses that have these auctions, and a lot of them have quite radically different auction conditions. But it seems that the sort of common theme now for most of the online auction houses is that the highest bidder, in essence, as a result of being the highest bidder, is given a reservation period. So they are given a window of opportunity to proceed to an exchange of contract and completion. The second thing that's really interesting is that when you have a deep dive into the auction conditions, the online auction houses are really cute. What they're saying, in essence, is, look, we're not liable for any information that we generate in our marketing material relating to these properties. We're relying on the seller or the seller's lawyers to provide us with information which we're just duplicating. And therefore, if it's wrong, you can't sue us. Now, there's two things with regard to that. One, is that possible? Can you exclude that liability? Well, there is a contractual relationship between the highest bidder and the auction house theoretically, but does that contractual relationship establish any form of liability in those circumstances? Probably not. And the other issue is, does that not mean that the seller's more vulnerable to a misrepresentation or misdescription claim? And I think the answer to that is an emphatic yes. The other thing that buyers were saying to me a lot was, we don't realise that, yes, we're entitled not to proceed to exchange of contract if we don't wish to. So we've got an exclusivity period. We don't have a legally binding contract if we're the highest bidder. But if we don't exchange contracts, we lose out on reservation fees, etc., that we've paid over. And if you have a drill down into that, a lot of the reservation fees, etc., that a prospective buyer is going to pay, in essence, is covering the marketing costs of the seller. So instead of the seller incurring fees from an estate agent, the seller is relying on the services of the online auction house, but the online auction house fees are being paid by the highest bidder. Zara raises a question. What about these modern methods of auction? Is it the same thing? Getting auction packs with no searches and bits of information. A lot of them seem to be done under probate. Yeah, they are. That's a face-to-face auction as well, Zara. Yeah, again, it's an issue. But with a face-to-face auction, generally speaking, if you're using the RICS auction conditions, the contract is made between the seller and buyer at the fall of the auctioneer's gavel. With an online auction, it seems if you're the highest bidder when the auction closes, you enter into a reservation agreement with the seller acting as with the auction house acting as agent for the seller, and then you have a period of exclusivity to proceed to exchange and complete. Expecting that the buyer then instructs solicitors who perform due diligence. Well, there's a number of problems there. One, is there sufficient time in the exclusivity period to perform proper due diligence? Two, do the auction conditions compel the seller's solicitors to produce an auction pack to the successful highest bidder? And three, what happens if the auction pack is defective or the auction house materials are defective? Well, there's been a few cases, one case called County Mayo Estates, where the courts have said with an online auction, the auction house and the seller should assume that the successful highest bidder may be buying blind. And if that is the case, the auction marketing material or the auction particulars need to be very careful. If they're describing a property as a development opportunity, then it's necessary for the auction house to disclose any issues in the title that would mean development would be unlikely. So that again, there's some shifting sands with regard to what the seller is obliged to disclose. So the seller doesn't have to disclose the title or produce a sort of report in the marketing material, but the marketing material must refer to, for example, a title that contains an overage provision, or if a title is being sold as a development site but is burdened by restrictive covenants. Right, charge 6 to the buyer. I mean, if the buyer doesn't go ahead, the buyer loses this sum of money. Yeah, that's one of the auction houses that was mentioned, Zara. Yeah. And again, you know, a buyer client thinks, well, I'm going to get that back if I don't proceed to exchange of contract. Well, the answer to that is you don't. Okay, so anyone had any problems or encountered any issues with online auctions? Do watch your auction particulars. Do watch your auction conditions of sale, reservation agreement conditions, and do be aware that auction houses can alter their auction conditions at any point up until the auction starts. Same thing with regard to a face-to-face auction, remember. The auction house can announce at the start of the auction that the auction conditions are varied generally, or that the auction conditions are altered in connection with a particular lot. The next thing I wanted to discuss was the Leasehold and Freehold Reform Act 2024, and some confusion relating to it. So I'm just going to pull up some work I was doing yesterday on this and just share it with you. If I can find my notes somewhere, which I'm sure I can. Bear with me a second. There's some interesting stuff here that I wanted to explore. Firstly, as far as the 2024 Act is concerned concerning rent charges, that now is in force, but doesn't apply to estate rent charges. And again, the number of problems I'm encountering with regard to estate rent charges is staggering, and therefore it is important to be very careful about making sure that you're giving appropriate advice relating to estate rent charges and the negativity associated with them. The other point that I want to mention, again with regard to the Leasehold and Freehold Reform Act, is that there is part of the Act that comes in force on the 3rd of March. So I'm just going to have a look at that if I can. Just bear with me. Just pull up my slides that I was looking at yesterday. So a lot of the sections of the Act dealing with right to manage, qualification periods for lease extensions, etc., are live as of the 3rd of March. If anyone wants a sort of resume sheet about that, send me a note and I'll get it across to you but there's some interesting stuff relating to it that you could have a look at. Next thing that I wanted to talk about, just trying to pull up something else, actually, just bear with me. I'll see if I can dig something else out about that I think is important. Yeah, someone was asking me about common hold and, you know, when this draft legislation is coming out relating to common hold. And for those of you that are worried about the relaunch of common hold, it was in the King's speech that the current government is going to relaunch it. A draft bill is envisaged at some point in 2025. So it's not something to get really worked up about at this moment in time. Okay. Right, the next thing that I wanted to explore was this issue concerning first registration, a case called Bolden against Bowler. I don't know if you've seen this. What happened is the claimants in this land, in this case, applied for first registration of some unregistered land adjoining their property. And the position was that the neighbours, Mr. and Mrs. Bowler, objected to the application. Now, they didn't object on the basis that they said their land belonged to them. They objected on the basis that they claimed that the land that was being subject to first registration was land over which they had a right of way and a right to park cars. Now, unfortunately for Mr. and Mrs. Bowler, they did not appreciate and were not advised that the right of way and the right to park were overriding interests that would override the first registration process, meaning, in essence, their rights were automatically protected. Application for first registration made, and significantly, the Bowlers object. Land registry allow the parties a period of time to try and negotiate some form of settlement, which came to naught, and therefore land registry refer the matter to first tier tribunal. So you have an application for first registration, an objection from Mr. and Mrs. Bowler, and the objection is we have a right of way and a right to park over the land, and therefore we think this title shouldn't be registered. Completely misinformed, and an application with no merit whatsoever. Application dealt with by way of first tier tribunal. Mr. and Mrs. Bowler lose and are obliged to pay Mr. and Mrs. Bolden's legal costs. Why do I mention this case? Because what you've had here was a situation which I don't think people appreciate. Anyone can object to an application for first registration. But whenever you are objecting to anything involving land registration today, the applicant needs to understand and appreciate the consequences of objecting. And those consequences are as follows. 1, you're going to be bounced into first tier tribunal proceedings. 2, those first tier proceedings are not proceedings that are sort of informal. First tier tribunal exercising its land registration jurisdiction, very formal process, strict timetables, strict rules of evidence, no opportunity to unilaterally withdraw, and if your application is unsuccessful, you are liable to the other side for their legal costs. So Mr. and Mrs. Bowler make an objection that is totally unfounded and get clobbered as a consequence. The other point is to be aware of the existence of overriding interests. And this goes back to the client inspection point. Whenever you've got anyone buying a property, registered land or unregistered land, the client needs to understand that when they're inspecting, one of the things they're looking out for is the existence of anything that could potentially amount to an overriding interest. So again, as far as that is concerned, it is critical that you are aware and your client is aware of the importance of inspection and the need to make sure that if the client sees something that potentially could be an overriding interest, it's reported back to you. It follows from that, doesn't it? You've got to explain to the client what an overriding interest is. So Bolden and Boller, interesting. I've written about that in the February edition of Property Law UK. There's also some other interesting cases in there. There's one or two about boundary, some interesting cases concerning boundaries. There's an interesting case concerning property joint ventures. There's all manner of different things. If anyone hasn't seen Property Law UK, drop me an email and I'll endeavour to arrange for you to get a copy sent out to you to have a look at it. It is a subscription service, unfortunately, but there is some interesting stuff in there that you can have a look at. Right, the next thing I want to talk about is rejuvenation of the high street. So again, someone was asking me about acting for clients who are buying flats and apartments in converted or mixed-use buildings. So again, a lot of high street rejuvenation isn't the reinvention of retail, but is looking at alternative uses. And as far as that is concerned, you've got an opportunity for the conversion of retail and office accommodation reused into residential. And therefore, what I want to show you is some interesting stuff. There's a really interesting sort of presentation produced by Landmark Chambers, set of barristers' chambers. And it was led by a lady called Catherine Holland, KC. But it's a really useful exercise in what you need to look out for if you're acting for a developer who's undertaking this type of project, or what you should be looking out for if you're acting for a resi buyer where a building is mixed use or converted from office or retail. And just looking at this, first of all, you've got the Ministry of Housing, Communities and Local Government back in 2018 saying, hey, this is something that we should be looking at because of failing high streets and demand for housing. The next thing is it looks at the Use Classes Order 1987 and General Permitted Development Order 2015, which allows change of use from commercial business and service to dwelling houses. So that's MA to Class E. And Class M, laundrettes, bedding offices, loan shops for hot food takeaways, to again, resi. And Class N, casino or amusement arcades, to Class C3 as well. And therefore, you've got the opportunity for permitted development. As far as that is concerned, however, if we're changing Class E to C3 residential, prior approval might be required by planners where what's being planned or proposed will impact on transport to make sure that the commercial unit has safe access for residential purposes. Again, prior approval might be necessary where there are flood risks relating to the building. If what is proposed could impact on residential occupants or purchasers from noise from a nearby commercial premises, making sure there's adequate natural light into habitable rooms, to make sure that fire safety is taken into account. And here, of course, we couldn't proceed, could we, without having our daily dose of the Building Safety Act. So fire safety, building containing 2 or more dwellings over 18 metres or 7 stories in height. Remember, everyone, this becomes a higher risk building. And where we have a higher risk building, a few things need to be you need to be aware of. One, a building that is being converted or built that will become a higher risk building. One, there's a necessity for a completion certificate before any residential occupier occupies. And 2, there's a need for the building to be registered as a higher risk building. 3, remember what was said in the Grenfell Tower inquiry report. The idea of classifying a building as higher risk purely on height or number of stories is too arbitrary. And what the government is currently thinking about is altering how we define a higher risk building to take into account more subjective issues like who's in fact in occupation. So the example I always give here is what happens if you have a 20-story tower block that's occupied by students and youngsters, all of whom are able to safely evacuate the top floors within 10 minutes. as opposed to a 3-story building that's occupied by elderly or infirm owners or occupants, in which case a 10-minute deadline for evacuation may be entirely unfeasible and impractical. So we may see a change in definition of what a higher risk building is, which I think, if it's expanded to try and take into account occupants, is good news, but is really detrimental to you and I, because it means that the status of a building could change depending on who's in occupation, and could mean a great deal of additional work is necessary to identify the current status of the building. The other point to note, which was someone asked me about last week, remember when we talk about building safety risks in the Building Safety Act, it's always envisaged that the concept of what is a building safety risk could also be expanded. Helen's going back to auction. Hi, Helen. We deal with all sort auctions, who I know very well. Buyers looking to develop a lot came to light when visiting the site after exchanging the adjacent adder notices indicating the presence of adders, a protective species. Is it still the responsibility of the auctioneers to disclose if it's on adjacent land? I would say the answer to that question, Helen, is no, it's not, unless the seller was aware of the existence of adders. Because my guess is an adder doesn't sort of respect property barriers and will slither from one property to another without too much difficulty. So the interesting point there, Helen, is with the auction pack, do you get TA forms, or did you get TA forms? And what did the seller say? But adders, newts, bats, all of these things, wildlife generally, can create mayhem, can't it? But I think to answer your question, I would say it's not the responsibility of the auctioneers to disclose it on adjacent property. Zara, hi Zara. Lenders asking on new builds to confirm the outstanding works and no cost will be passed on to leaseholder, but you can't guarantee a never. Turns out the one I got, an EWS1, the developer's gone bust, and the EWS1 is not in the name of the housing associations. Right, sold by receivers. So yeah, Helen, I think you're high and dry on that one. If there's an interesting question, if you had a protective species on land, is there any sort of local authority obligation to record the existence? I don't think there is there? I don't know about that. I'm going to find out about that. Things like bats and newts, etc. You know, how do you know? If the seller doesn't know, how do you know? Right. Has anyone had any problems with the EWS1 and that company where the guy who was the director of the company and owner of the company was producing EWS1s, which were defective, and was signing off EWS1s when he'd been suspended, etc. Someone asked me a question the other week about if I've got an EWS1 that was from that company, but was issued before the guy's suspension, can I rely upon it? And my guess is, or my answer to that question is, I don't think you can. But I'd be interested to hear what anyone else has to say. But remember, on Zara's point, what is an EWS1? It's not a fire safety certificate, is it? So it might be useful document, certainly for a builder or developer, but from a buyer's perspective, it seems to be an issue, doesn't it? Because, you know, as a lawyer, can you advise on an EWS1? I don't think you can. Thanks for that, Zara. That's the link. I'm going to take a picture of that and have a look at it after today, because that's interesting. But in short, you've got, as far as the 2024 Act is concerned, a few things. One, you've got part of the Act in force in July last year, parts of the Act in force as of October last year, and some of the Act coming in force on the 3rd of March. And I'm just coming up to my notes on it. I'll tell you what, there's an interesting case as well. I'm just noticing this case called Van Zyl against Walker Smith, boundary dispute. And again, just the court emphasizing the fact that there was a hedge which appeared to be the boundary line. And the court basically saying that, you know, you must look to the parcels clause describing the land rather than the plans annexed to a transfer or conveyance to identify boundary. Right, let's just have a look at this. Sorry about this. I'm skipping around and failing miserably. Quick question. Got a client asking where the boundary land is where there is a right of overhang. I don't think there's such a thing as a right of overhang, Zara. What you do have is there is a case where a guttering that overhung an adjoining property enabled a neighbour to claim adverse possession of airspace. So is that the point you're making there? And Zara, did you ask Fiona about that, about Adam Kiziak? Is that where you got that information from? Joe, when acting for a seller, we're aware the EWS1, all right, thanks for that, has been signed off by Adam Kiziak, but no inquiries have been raised by the buyer solicitor. Do we, as sellers for solicitors, need to highlight and disclose it? The answer to that is no. You, as the seller's solicitor or conveyancer, wouldn't be obliged to do that, Joe. But if your client was aware of it, then it may be necessary for that to be disclosed in the TA forms, because that information would be a factor that someone would need to know about in connection with the property. I think that's how I would deal with it. What does anyone else think about Joe's point there? Acting for a seller, EWS1 signed off, but no inquiries raised by the buyer's solicitors. You know, if your client is saying that I'm not aware of any problems or issues relating to the property, then that is a problem or issue relating to the property that should be disclosed. Right. Yeah, if you're aware of an issue, then you're not obliged to disclose it. But what about the seller? Zara is the point. I think you're right with regard to the conveyancer. And Sue, yeah, HMOs, associated licenses and planning, great. Yeah, happy to do that. I remember years ago, I did a load of training on housing multiple occupation. I haven't done much for a while, to be honest with you. So obviously, it's an area that you'll be involved in an awful lot, given your line of work. Yeah. Okay. Anyone else got any points or issues? While we're waiting for that, I just want to mention the Association of Residential Managing Agents has disappeared into the ether, hasn't it? There's now an organisation called the Property Institute, isn't there? Has anyone seen the Property Institute website, or anyone know anything about the Property Institute? Hi, Joanne. Joanne, hi. Oh, we've quite used the new TA6 forms now. You're not obliged to, are you, everyone? You can use it, but you're not obliged to, as I understand it. Is that right, everybody? Yeah. Not yet. So, but Joanne, some firms are, and Joanne, what I say is, if you are, yeah, they haven't. You're right, Zara. The point with regard to the revised TA6, Joanne, is this. I think you need to be careful if you're acting for a seller. And what you need to say to the seller is, if you've provided, or the estate agent provided, any information to the buyer or prospective buyer before you've instructed me, I can't be held liable for any issues arising from that information being defective. That's point number one. Point number two, I think it's a matter for you as to whether or not you're prepared to check if material information has been disclosed, or if part one of the TA6 has been completed and made available to a buyer. It's up to you, I think, whether to check, whether to confirm whether you're prepared to check that information and advise the seller to remedy it if it's defective or not. So I think we've got to be careful with that. And I think the other point with regard to the revised TA6 form, Joanne, is that we need to be proactive with regard to some of the questions in the revised TA6, because the TA forms are saying to the seller, you fill these forms in on your own without any legal advice. Okay, that's the warning on the front of the forms, isn't it? But in some of the questions, there's one about restrictive covenants, there's one about third-party rights. They're saying, if you're not sure about how to answer this question, consult with your solicitor. So I think what you need to do in that situation is, where a client asks you for assistance, is make sure that the client is aware of the extent of the assistance you're providing. So what you're doing is saying to the client, that, you know, when we talk about restrictive covenant, this is what is meant by the restrictive covenant. And here's a copy of the charges register with the restrictive covenants. I don't think we can answer the question for the client or tell the client the wording that should be used to answer the question. Does that make sense? Zara Sink says the TA7, people thinking yes to having qualified. Yeah, Well, Zara's all, I mean, I've seen all sorts of crazy things with regard to the TA7. The key with the TA7, if you're doing BSA related work, is to provide your client with an information sheet that explains the terminology that's used. So again, you know, I'm conscious of us not giving clients advice with regard to the revised TA7. But I'm also conscious of the fact that if a client is just left to fill it in on their own, they're not going to have a clue about what a qualifying lease is. So I've produced somewhere an information sheet, which I'm happy to share with people. So it gives the client guidance relating to the TA7 without giving advice. So I'm happy to share that with anyone attending today. Yeah. So I've just put my email address on there. Do drop me a note by email. I'll send that across to you, as well as the Leasehold and Freehold Reform Act sort of list of what's in force and when. Okay, we've got a couple of minutes left. Anyone got any other points to note? Any other issues? Everyone's busy in it at the moment. It's crazy. And even though I'm of the view, like was saying to Robert, that, you know, the stamp duty issue is causing pressure and causing work, it seems to me it's not as bad as it used to be, you know, last time around in lockdown. It's not quite as crazy. Or perhaps is that wishful thinking on my part, or because it's still relatively early days? Donna, yeah, not a problem. Drop me an email. I'll get that out to you. It won't be today, probably sometime tomorrow, but we will get it across to people. Fantastic. It is 1:30, so all there's left for me to do today is to say, right, we've already got a topic for next month, which is brilliant. We've also got our friends at the Nationwide coming along, so I'll remind them that they should be wearing helmets and body armor. But you've got to admire their tenacity for being prepared to come along, so that'll be good. Meantime, if you have any questions or queries for topics or anything, other questions or queries that you want, drop me a note by email. If anyone isn't coming along to one of our conferences, please inquire about it. Come along, it'd be great. We've got loads of really good speakers, loads of stuff, and you'll meet Mr. Robert Kelly and the team in person. So do come along to those. Hayley, my pleasure. Lynn, my delight. Jazz, thank you. Joanne, Zara, everybody else, Angela, thank you so much for giving up your time today. Massive thank you to Stewart Title for sponsoring today's event. Enjoy the rest of the day. Stay safe and speak soon.